Hi, I'm Lauren Bernard. I'm the marketing director at Mac Murray Shuster, and I am here with Josh Stevens, who is one of our attorneys extraordinaire. Josh helps lead our privacy practice area group, and if I'm honest, he's one of my favorite attorneys. So I'm very excited to be here with him today. Hi, Josh.
Oh, shucks, Lauren, the feeling's mutual.
So Josh and I have been talking. There's so much going on with privacy laws and enforcement trends. I know it's really hard to keep up. And so I know, Josh, that you are working with clients every day on all of these developments, and you are getting lots and lots of questions. So we thought it would be helpful to just take a couple of minutes and maybe provide some quick information to folks to help them make sense of all this activity and its impact on their business. Sound good?
That sounds good to me.
Excellent. Okay, so Josh, I asked you, what are three things every business that's concerned about privacy should be paying attention to right now? And you had no problem listing them off the top of your head. So here's what you said. First thing, state privacy laws. What's the latest on those? What are some of the takeaways that can help businesses move forward?
Yeah, so it's been a busy year so far. We've had multiple privacy laws coming into effect here in 2023. Just a reminder for everyone, California's privacy law the update to it came into effect January 1st. Its enforcement date's July 1st. We also saw Virginia come into effect in January. Colorado, Connecticut are in effect in July, Utah at the end of December. It's a busy year for laws that passed in the past last year before. But it's also been a busy year for new laws passing. And so we have seen privacy laws, comprehensive privacy laws pass and this is in no particular order, Iowa, Indiana, Tennessee, Florida, Texas, and Montana. And Texas, I will tell you, caught me by surprise. I was not expecting to see a privacy law pop up out of Texas this year, but what are you going to do? There's always a surprise. But those laws come into effect, depending on the state, somewhere between 2024 and 2026. And what this is really showing is the state privacy law trend is continuing, and it's continuing to grow. In the absence of federal legislation, the states are taking it on themselves to fill in that gap. And businesses really have to keep up with these, and it's something that can be challenging to navigate. Sort of reminds me of telemarketing laws, right? Telemarketing laws vary state to state. And so here at the firm, you and I joke that we're the 50-state survey kings and queens, right? Because we're constantly having to keep up with those things. And it's sort of the same thing with the privacy laws now, as they're continuing to snowball.
Gotcha. So you listed a bunch of states up front there. Any predictions going forward on some states that maybe businesses should keep their eyes on?
Yeah, so Washington State is always the perpetual Ross and Rachel of, will they, won't they? We've seen privacy legislation proposed there in multiple legislative sessions that has come very close to passing, but never quite gets across the line. And so we'll see if 2023 or 2024 is the magic year for that to actually happen. New York also seems to be aggressively pursuing privacy legislation, and I think that's to be expected. It's a big state, of course, that's something that they would be concerned about. So I would not be surprised to see passage of privacy legislation in New York soon as well. But what's been really surprising, if you think about the states that I listed, many of them are what we would sometimes refer to colloquially as red states, right? They're states that have Republican-dominated legislatures. And traditionally, red states tend to be lighter in terms of regulation. But we're seeing a lot of these Republican legislatures actually taking the lead on the privacy front. And, you could speculate as to why that's happening. The hullabaloo around TikTok could be part of what's driving it, and related concerns. But I wouldn't put those sort of quintessential red states out of mind. They're definitely moving forward in this path. And one of the things that's interesting about it is they're mostly coalescing around the model that was put forth by Virginia and Colorado originally. And that seems to be the model that's taking root in these new laws that are being passed and in what states are considering. Every state's got its own nuances, but that seems to be the model that's becoming dominant.
That's good to know. So Colorado and Virginia kind of setting the pace for other states. Never say never when
Never
it
say
comes to
never.
red states. And brownie points for you, extra points for you for getting a Friends reference in there. So well done. Okay. Second item you said was Washington State's My Health, My Data law. So talk a little bit about what that is and why that should be on everybody's radar.
Yeah, so while Washington State hasn't been able to get comprehensive privacy legislation through yet, they were able to get through this new bill called the My Health, My Data Act. And what this bill is intended to do is protect consumer health data that's collected outside of a HIPAA context, right? So remember that HIPAA, the federal healthcare privacy law, applies to personal health information in a certain context, right? And that context is typically when you're at the doctor or a therapist or the pharmacy, or maybe you're participating in a research study that comes under HIPAA, right? It's your more traditional healthcare context. What Washington's trying to do is plug a gap that emerged where we now have a lot of businesses, particularly with mobile apps, that are not healthcare providers, but they're providing health adjacent services. So maybe they allow you to track certain healthcare or health data, right? Your blood pressure, your heart rate, things like that. There was kind of a few months ago some hullabaloo around menstrual cycle tracking apps, right? And different things that can really get some intimate data that the consumer is providing, and they're not healthcare providers, so they don't come under HIPAA. This Washington law steps in and says, if you're collecting consumer health data, then you've got to have a consumer health data privacy policy. There are consent requirements depending on what you're going to do with that data. There are limits on how you can use that data, how long you can keep that data. It's trying to set a framework to give extra privacy rights for what many people would consider their most sensitive information.
Gotcha. So what should you look for? What should a business look for if they're not sure if they fall under this or not?
Yeah, so it has a pretty expansive definition of consumer health data. It obviously includes things that you would think of, like your heart rate or your blood pressure, or medical diagnoses, genetic information, things like that. But it also captures indicators that you may be trying to get healthcare services. So this is where we're seeing a number of our clients who are potentially at risk is with geolocation tracking. So if their geolocation tracking could reveal that a person was trying to access healthcare services, so say it shows that they made repeated visits to a certain doctor's office or things like that, then that can potentially be consumer health data under this law. So it's really important to look at not just traditional health data, but also these healthcare adjacent pieces.
Okay. So Josh is back. If there's a pretty hard cut there, I apologize. You cannot predict when a UPS delivery is going to come in the middle of brilliant delivery of content. So
sure,
I think
sure can't. But but it goes to this point about geolocation tracking that I was just talking about. That if they offered precise geolocation tracking that you could pick up and look at in the app to know when things are going to be delivered, that would be a real boon to
there you go.
to their service.
I agree. I think you did get through all of your answer for number 2. So I'm going to jump ahead to number 3, the third thing on your top 3 list. And that is SIPA, or the California Invasion of Privacy Act. So litigation really seems to be heating up in this space as TCPA cases are declining. So enlighten us on what's going on there, please.
Yeah. So adversity is the heart of invention, right? And so what we're seeing is as TCPA cases are starting to fall away because of the Supreme Court's narrowing of the concept of an auto dialer in the Facebook v. Duguid case, the plaintiff's bar is looking for other avenues to bring lawsuits and they would say advocate for consumers. Some might say extortion, but they're looking for new routes. And one of the ones that's become popular is SIPA. And this is essentially California's anti-wiretapping law. And what the plaintiffs are arguing is that the use of certain online technologies can violate this law because they intercept or record communications, and California is an all-party consent state for the recording of communications. And where we're seeing this coming up the most is in two particular pieces of tech. One is session recording or session replay software. This is software that you build into a website that lets you visualize how consumers interact with the website because it records their mouse movements, keystrokes, where they click, things like that. And so that's one area that we're seeing these cases. The other has to do with the Meta pixel, formerly the Facebook pixel. And the argument there is that by allowing this pixel on your website, you allow Meta to capture the HTTP GET request that's coming from the user's device to the website in transit. And that's getting recorded by a third party, Meta, right? And so these are still fairly new in their genesis. What we are seeing is, particularly around the metapixel, clients are getting demands, relatively moderate amounts of money, depending on the size of the business, it hurts more or less, but they're in the low 5-figure range, usually is what we're seeing. And as individual claims, we're not really seeing a lot of class actions yet around this, except in the healthcare space. That does seem to be an area where that's popping up a lot, but we're mostly seeing individual claims. But we're seeing a lot of them as people are going around. Pretty much every website has the metapixel built into it. And so you go, you troll, and you send a demand. And that's what we're seeing.
And we know from the TCPA that it doesn't take a lot of claims. It doesn't take a lot of 5-figure claims to turn into a 6-figure claim.
True.
Ultimately, or to add up to a 6-figure claim. So talking about, I know, SIPA is growing. I don't think that means that TCPA is going away completely, but I know you've talked about how TCPA cases are looking different themselves too. So can you talk a little bit more about the TCPA in respect to them?
Yeah. So post Duguid, ATDS cases under TCPA have really fallen off a cliff, right? They've dropped significantly because that concept of an ATDS was narrowed by the decision. But we're seeing a renewed interest in cases around do not call violations and violations related to pre-recorded messages, particularly where businesses are using artificial or synthetic voice systems. And so, AI and the use of AI in technology in communications is really taking off, right? We've seen this with ChatGPT, but long before that, businesses have been developing these kind of chat bots, right? That you saw mostly online as text chat bots, but now they're getting smarter and they're becoming more like virtual assistants. And so some businesses use them for outbound calls, not just to help on inbound calls. And so there's a risk with those, that those are pre-recorded messages because they're artificial or synthetic voice. So that's where we're seeing renewed interest in TCPA. The other thing we're seeing, though, is a shift away from TCPA specifically into state law claims. And so Florida was where this first really popped up, when they made a change to their law that made the definition of an auto dialer very broad, with an automated system for the selection or dialing of numbers. And so we saw a flurry of litigation in Florida. Well, they fixed that language. And so that's not going to hopefully be as big of an issue moving forward. But we're seeing other states take interest in that language. And so Oklahoma and Maryland have both brought that language into their statutes. It's very possible that other states may do so as well. And so what we could see is a shift of what we might refer to as TCPA cases that are related to an auto dialer from being brought under the TCPA to being brought under state laws.
Gotcha. Gotcha. So easing up in some areas, kind of with the ATDS, but definitely still heating up in others, because where there's a will, there's a way.
Oh,
and I guess might be a way to look at it. Okay, so 3 things. Those were your top 3: state privacy laws, Washington State's My Health, My Data law, and growing SIPA cases. I got to end this on a positive note. So we've just talked about 3 things that folks need to keep their eye on. Give us a piece of good news on the privacy front going forward.
Yeah, so I think the biggest piece of good news is that it does seem states are coalescing around that Colorado, Virginia model. And I think that's good for a couple reasons. One, it does provide consumers a robust set of rights. And so from a consumer perspective, it's really beneficial. Second, it's a little bit more streamlined than the California law. So it gives businesses a little bit more flexibility in implementation. And there are some exemptions in it that aren't in the California model. So I think that's a good, that's a nice balance. And then lastly, just the fact we're coalescing around something is good, because that means that once you build out that privacy compliance program for Colorado and Virginia, you may need to make some minor tweaks to it for the other states, but it's largely going to be the same. And so as each new state comes on board, as long as they continue to sort of follow this model, it should be fairly easy to make those tweaks and extend the rights to consumers in that state without having to build a whole nother program.
That is good news, actually, so that you're not necessarily dealing with a completely fragmented set of requirements across the states. So that's it. That's our 3 things. Hopefully we've shared some helpful and quick information to folks out there. Obviously, if you have any questions on anything that's been discussed or anything outside in the privacy, consumer protection, telemarketing realm, Josh is your guy. You can reach him at jstevens@mslawgroup.com. You can also sign up on our website. That's mslawgroup.com, and you can receive news and insights on these topics and others directly in your inbox. I don't know, Josh, what do you think? Maybe we'll do this again sometime. This has been fun.
So it was fun. And maybe next time, I won't have a package delivery in the middle of it.
Well, I hope it's a fun delivery. So thank you again, and hopefully we'll see you soon for another one of these.